Much, and thank you for your kind invitation to appear before this committee to assist in its important study of Bill C-27. I'm a partner in private practice at a law firm where I've been practicing privacy law for 22 years. Most of my practice involves advising international businesses on having to comply with Canadian privacy laws, and more often than not, they're trying to make their existing privacy programs that they've developed in places like Europe and California work in Canada. I also advise Canadian businesses, large and small, in compliance with these laws, and regularly advise organizations in connection with investigations and encounters with the Office of the Privacy Commissioner of Canada and his provincial counterparts. I'm here in my own personal capacity, but obviously my work and opinions are informed by my experience working with my clients. Now, I may come across as somewhat contrarian in saying this, but I actually think that PIPEDA works pretty well as it is. It was designed to be technologically neutral, is based on existing principles that are largely embedded in Bill C-27, and one thing I've often said is C-27 takes PIPEDA and turns it up to 11. I don't think the legislation is necessarily broken, and I do think that the Commissioner has, over the past 22 years, not necessarily exhausted all of his enforcement powers and authorities over that time. I'd like to start by saying that I don't really like the name of the new statute. Canadians aren't simply consumers. This legislation applies to consumers. It also applies to certain employees in the federally regulated sector. It's a little bit negative and dismissive. If we're wedded to the acronym CPPA, we could call it the Canadian Privacy Protection Act, but I don't think that actually affects its substance. Now, I like PIPEDA, but over the last little while, it's pretty clear that there's an emerging consensus looking towards order-making powers and penalties, thinking that they're desirable. And in the course of doing this, I would ask the committee to consider that requires a commensurate and appropriate increase and shift for greater procedural fairness, and that would be more than is currently in the bill. I'm of the view, based on my experience, that the Privacy Commissioner has a bit of a conflict, or potentially a conflict, in being a privacy advocate, privacy educator, privacy police, privacy judge, and privacy executioner. Any determination of whether a violation of the CPPA has taken place and what penalties should be imposed should be carried out by an independent arm's-length tribunal, such as the federal court or such as the new tribunal. The Commissioner can recommend a penalty and can take the role of the prosecutor, but ultimately the determination of whether or not a violation has taken place and whether or not a penalty should be imposed should be vested in an arm's-length body. I think the recent Facebook case in the federal court is a bit of a cautionary tale, and I'd be happy to talk more about that. Children's privacy is obviously a very important theme in this particular piece of legislation, and I agree and appreciate the views of the government and the Commissioner with respect to protecting the privacy of children. One thing that I'm a little bit concerned about is that the current bill would be difficult to operationalize for businesses that operate across Canada. Whether or not somebody is a minor currently depends upon provincial law, so that varies from province to province, and implementing consistent programs across the country, that would be difficult. I would advocate for putting in the legislation that a minor is 18 years or below. I would also suggest that there should be a presumption that children under the age of 13 are not able to make their own privacy decisions, and their parents should be their substitute decision makers by default. And for organizations that have a general service to the public, like a car dealership, for example, there should be a presumption that all their customers are adults unless they know otherwise. So if you have a website that's focused towards children, you know that there are children in the audience, you have to calibrate your practices appropriately. Anything different might lead to mandatory age verification, which can be very difficult and raises its own issues. Having been involved in investigations and also having been involved in litigation involving privacy claims, I would suggest that the private right of action should be amended to be limited to the Federal Court of Canada. If you're wedded to a private right of action to begin with. The problem is, with the existing legislation, anybody can go to the Federal Court of Canada or to a provincial court. And we know that there are going to be hundreds of people affected over the next decade or so with respect to particular incidents. And so you're going to end up with duplicative proceedings simultaneously across the country, which we already know that judicial resources are significantly taxed. I think legitimate purposes, which is largely based on the European model, needs to be more closely aligned, and I'm happy to provide more details with what is happening in Europe. And with respect to the Artificial Intelligence and Data Act, it should be its own statute, its own bill, subject to its own study. But I would note that excluding government from it is dangerous. Government has guns. Government decides about it benefits, immigration, things like that. I think it's subject to a constitutional challenge. It's not necessarily harmonized with what's going on with their international trading partners, and there should be reciprocal recognition. If a company is complying with European data regulation, and we have deemed it to be substantially similar, that should work. Otherwise, we're going to have difficulty with Canadian businesses operating internationally and international businesses coming here. And finally, I think research and development should be removed from the bill because it presents no real risk of harm to an individual until it's presented into the public. I have a longer list. I could go on for much more than 5 minutes, but I think that's my time, and I look forward to the discussion.
Like to ask Mr. Fraser in the little bit of time I have left. You mentioned, and I think ADA is a problem because ADA actually doesn't set out a public policy framework, which is what legislation is supposed to do. It just says, trust us, we'll do it all in regulation. But you mentioned that it would be perhaps open to charter challenge, and I wonder if you could expand on why.
So the conclusion I draw on that is it's simply saying within the legislation or saying within the bill that it applies to artificial intelligence in connection with interprovincial activities. The federal parliament has very little jurisdiction, for example, over computer science researchers sitting at the University of Toronto. That's exclusively within provincial jurisdiction. So there are going to be scenarios in which federal jurisdiction may be triggered, but in the vast majority of situations when a small company in Nova Scotia or a small company in British Columbia decides to implement an artificial intelligence system, that's not within the competence of the federal parliament when they do it on that small scale. So there are going to be significant gaps with respect to where federal jurisdiction can apply and where provincial jurisdiction already applies.
And maybe I'll start with the witnesses that are online. I'd like to get everybody's position on the tribunal, whether you're in favor or opposed. Mr. Fraser, and across the board here. Yeah.
Sure. So starting with the assumption of having order-making powers and penalties, we do need to have an independent decision-maker, in my view. That could be the tribunal or that could be the federal court. I don't see why it couldn't be the federal court. And I'm concerned that standing up a tribunal is actually going to delay the implementation of this legislation because that's going to take a number of years simply to hire the staff, rent the photocopiers, all those other things.
Great. Thank you, Mr. Fraser. Mr. Theron, and then we'll get to...
I'll try to be brief. The goal, I think, of these provisions should provide quick and effective remedies for citizens. In no other jurisdiction that I know of is there a tribunal such as that proposed in this legislation. In all other jurisdictions, in privacy, the original decision maker, including with the power to make orders and fines, is the Data Protection Authority, that is the equivalent of the Office of the Privacy Commissioner. I hear concerns about the difficulty for the OPC to work with different roles. That is not a problem in other jurisdictions. It is well known in law that it is possible for an administrative tribunal to have investigative, advisory, and adjudicative functions. This needs to be managed. It can be managed, and there's no problem there. I think the tribunal will create delays and will simply be duplicative of the expert work of the Office of the Privacy Commissioner. And again, there is no precedent internationally for this.
Yeah, Mr. Kartash, I don't know if I have time. You can take it from my next round if I'd like to have him. Thank you, Mr. Chair.
I personally am fully in favor of the tribunal. I think it's important to start the conversation with looking at the sheer quantum of the potential penalties for contravention of the Act, which, comparatively speaking, with any other statutory framework is immense. Like with larger corporation, hundreds of millions of dollars. As Mr. Fraser mentioned in his opening remarks, it's absolutely imperative in a circumstance when you're introducing a regime with that level of penalty, it could be potentially impactful for businesses in every constituency here, that you just have a procedural fairness piece on that. And everyone agrees with that. This will add to that procedural fairness piece, and it will allow for, in my view, an appropriate articulation of whatever the penalty is or should be in a particular circumstance.
Okay. Thank you. Thank you, Mr. Chair. Just, again, with the tribunal, I know you had a little more to offer. Creating this type of a body, do you really think it could undermine, I think, the strength of the Privacy Commission in general? I worry about that because I know that the United States doesn't have this model, but for ourselves, I think it's actually served Canadians quite well. So I'd like to expand on the vulnerability if we change the route that we have right now.
Thank you for that. I think there is a risk of the OPC being undermined in the following way, at least. The federal office works with and has to work because data flows internationally and within provinces in Canada. The OPC works with colleagues in Canada and internationally. As I explained in my earlier answer, there is no other jurisdiction with the type of tribunal that is proposed federally under the CPPA. So that would put the OPC in a situation where when it conducts joint investigations with colleagues across Canada or internationally, its position would be less, certainly would be effective later than that of its colleagues, and it would have, the OPC would have to wait for the blessing of the tribunal for a for an order to be upheld or for a penalty to be imposed. So that's one thing. But I think even more importantly, Canadian citizens would have to wait longer than others in other jurisdictions, including in Quebec. The CAI in Quebec does have order making and fine imposing powers. So there's a difference in terms of the rapidity with which Canadian citizens would have protection compared with other jurisdictions.
Okay, thank you. Thank you, Mr. Chair.
Okay. Well, that sort of answers my question. Is we don't know, and what I hear from you today is we talk about consent as well. And my concern is the consent of a child. We don't have a definitive age for a minor in this legislation. Do any of you want to comment on whether we need to define the age of a child? And should there be different tiers of consent related to a minor in this legislation? And again, it all goes back to my kid on an iPad when I'm sitting on an airplane or we're driving somewhere and he's in the back and he's clicking on certain things. I don't know where that information's going, and I get scared about that. And I'm fearful as a parent, and I know every committee member around here has similar concerns that I do. How can we address that in this legislation to make sure children are protected?
I'm happy to weigh in with some thoughts because it's something I've turned my mind to. So in the legislation, it refers to minors, and minors is defined by provincial law. Minors are 18 in Alberta and 18 in Quebec and 19 everywhere else. So there's a different line. One of the challenges that I think exists with children and privacy is that there really are not easily drawn bright lines that say under this particular magic age, you are completely under the control of your parents and you have no ability to consent in a valid way. Or over this age, you're magically endowed with those particular powers. As a parent of three young men now, you can tell that at different ages there are different levels of maturity, and it's difficult to determine. The way that it actually works in practice is difficult to operationalize. That you have to take into account the individual characteristics of the young person, and are they able to, Mr. Teddian talked about the requirements for knowledgeable, informed consent. Is the child capable of understanding what it is that they're consenting to, what those consequences are? And it's actually tied pretty similarly to consent to medical treatment, and so it's not completely isolated in its own little world. But
I'm going to pass it over to Mr. Kardash just because that was a great point, Mr. Kardash.
A while ago, Mr. Fraser said that in his opinion, there should be an external tribunal and not an internal one. What is the fundamental difference? We understand that we have two visions. What Mr. Fraser wants something that is external. I think Mr. Therrien wants it to be internal. To be judge and jury, is there no risk that a lot of power maybe given to commissioners, maybe not so. At the same time, the commissioner is promoting privacy rights and the consequences of the bill if of the legislation if privacy is violated. Is there no potential conflict of interest? That's a possibility. I'm not talking about, I would rather not talk of risk. It's possible that the legislation, as a matter of routine, provide for that. There are many administrative tribunals. So the commissioner could have those powers without us having a tribunal, without being lawyer and adjudicator. Those powers should clearly be separated within the organization. And the final result, for example, an order taken by the Office of the Commissioner should be the subject of legal controls to make sure that the procedure was fair towards the companies. But such potential conflicts are often managed by administration tribunals without any problem. Mr. Fraser?
It's two different models. We also do have, for example, a Human Rights Commission and a Human Rights Tribunal, a competition commissioner and a competition tribunal. So there are other scenarios in Canada in which that particular model is applicable. And there is the possibility, and one would have to have controls and procedural safeguards within the Office of the Privacy Commission of Canada to make sure that those conflicts did not arise. I think that given the stakes that this legislation presents with multi-million-dollar penalties and even multi-billion-dollar penalties when you look at percentages of a company's global turnover, that not only that raises the requirement for additional procedural safeguards. You can think of it as a scenario in which a police officer can write a ticket and you can just pay the ticket and plead guilty and go on your way, or you can dispute it, and the police officer has the burden of proving in front of an impartial decision maker whether or not the facts alleged in that ticket are made out. And that would be the model that I would advocate for. Or maybe we can split the difference, and when it comes to anything that has a significant penalty over a certain threshold would require those additional safeguards. But those are going to be important. And I would also note, with respect to the new advent or we're seeing more and more multi-jurisdictional investigations taking place simultaneously, organizations are going to be subject to multiple penalties in multiple places arising from the exact same investigation, kind of multiplying that across. So the fine threshold in Quebec is pretty similar to the fine threshold here, and so you can find those being doubly leveled, which again, at least to me, raises the stakes higher.
Je veux pas que vous vous battiez, là, mais M. Terrien.
Mr. Terrien, what do you think about that?
Pour ce qui est du montant,
Talking about the amount of the penalties, clearly the penalties provided for in the law are extremely high. But it's the case in Europe, it's the case in other administrations, it's the case in Quebec with Law 25. And in all these models, without any exception, the first instance court, equivalent of the OPC, is able to make those decisions. I think there's a danger, as I just told Mr. Massey, that if the federal commissioner doesn't have the same tools as their colleagues, this could create significant complexities when they're dealing with other jurisdictions. Thank you very much.
The floor to MP Van Bynen.
I'm wondering if this legislation reflects the current state that we're in. Example, if we were 10 years back, would the legislation that we're proposing now, would we be in a different situation? And I'm thinking of Facebook, I'm thinking of GBT, I'm thinking of social media. For anyone who doesn't think that their privacy is already has an intrusion, either doesn't have a cell phone or a social media account, how can we change that? Or is the intent to control that? And how can we best do that? And I'll start with Mr. Fraser.
Well, I guess I would start with wondering whether you think that we should have a world without Facebook and ChatGPT and things like that. in my view, this legislation takes what we have existing in PIPEDA largely, and as I said, turns it up to 11. So it puts a greater requirement of diligence on the part of organizations in order to, for example, justify their decision-making, document risks, and do those sorts of things, and then has those substantial penalties. So had this been implemented 10 years ago, I'm not sure the universe would be all that different, because I think it's still based on the 10 principles from the Canadian Standards Association Model Code for the Protection of Personal Information, which are very Canadian principles with respect to privacy. Although I am very curious to hear from Mr. Tenia in terms of how he thinks it would have been different had he entered office with CPPA at his disposal.
Mr. Therrien.
I think the CPPA brings us much closer to where we ought to be in 2023. With the new advent or the new implementation of artificial intelligence, Part 2 of Bill C-27 is an attempt to align Canada's legislation to that new technology. Now, there's no perfect solution in all of these situations. There are people who think that that the Artificial Intelligence Act is so skeletal as to be meaningless, and there's some merit to this. I think it's okay for where we are today. I think one virtue of the legislation that is before you is that it continues with the consent model in many circumstances where consent can possibly be given, but it also recognizes that there are important limits to the consent model, hence legitimate interests and socially beneficial purposes. But I think the missing piece is that these additional flexibilities that reflect current use of technology have to be implemented within a rights protection framework. And although the minister's latest amendments bring us a bit closer, we are still quite a ways from where we ought to be, and that's why I recommended that Section 12 and 94 on penalties, particularly penalties, are important, because what's the value of having a recognition of privacy as a fundamental right if there is no penalty when you breach that principle?
Do you think that what we're introducing now is going to change the behavior and uses of data that's currently in the hands of some of these organizations?
We hope that with time, with not only penalties, but including penalties, but it starts with companies acting responsibly, regulators working with businesses to ensure that the law is actually being implemented. So there are advisory roles to the OPC that are important, but also with penalties, that the right set of incentives will be there for behavior to change.
Okay, and that this comes back to your suggestion that there should be proactive audits by the Privacy Commissioner to ensure that whatever additional responsibilities is being created through this legislation is being adhered to.
In brief, my point there is that it is extremely difficult, if not impossible, for individual consumers to understand how their data is used. It is even difficult for the regulator to understand how data is used. How will violations be identified if we rely mostly on individual consumers to make complaints? There are provisions, I know, for commissioner-initiated complaints, but the model we have is premised mostly on the basis that individual consumers will complain. In many situations, they don't know that there's a violation. So proactive audits exist in other jurisdictions that I've mentioned in my document, whereby the regulator can audit the practices of a company, not because there's belief that there's been a violation already, but simply to reassure consumers that this new practice actually does comply with the law, and therefore, yes, you can have confidence that it is privacy protected, or know that it is not, and then the company will have to amend its practices. So I think proactivity is extremely important.
Thank you, Mr. Chair. Thank you, Mr. Perkins. Briefly.
I had two, but I'll start with one. Section 35 says an organization may disclose an individual's personal information without their knowledge or consent if collected for statistical purposes or research. It doesn't identify by whom, but it seems to me to be a fairly open-ended breach of consent, being that I can give it to the government for statistical reasons, I can give it to a university for statistical reasons or research reasons without going back, and it's personal information. Could you comment on that, Mr. Thierry and Mr. Fraser?
There's already provisions that are similar to that, but with more safeguards in PIPED and other statutes that would require a privacy impact assessment or research ethics approval or reporting to the Privacy Commissioner. There's also provisions in the Statistics Act that allow Statistics Canada to compel that sort of information. I share your concern when it comes to something that's so open-ended. One of the things that I think is a hallmark of good privacy accountability is an analysis and a determination what are the privacy risks inherent in this and what are the mitigation steps that we can take. One thing that I would just also note is that so many of those provisions are discretionary. They don't require the organization to disclose it, but permit it to do so. But,
Mr. Thierry?
I would extend your question to a discussion that occurred a few minutes ago. I think here we're into the use of data for the social good. It's an example of use of data for social good. And I think it is, as Mr. Fraser said, there are similar provisions in the current Act. I think these are good provisions, provided that we really deal with the social good. Section 39 otherwise defines socially beneficial purposes. My colleagues, some of them have remarked that the socially beneficial purposes are limited to disclosure to public entities, and they make the point that private sector entities should be able to benefit from this. It's not inconceivable, but we need to be careful to disclose information to business for socially beneficial purposes.
It doesn't say that in Section 35. It doesn't say there's no
39,
fences around.
39 does. That's why I expanded your question to deal with social good, including 35 statistical purposes, 39 socially beneficial purposes. So I would say legitimate interests are the true domain of corporations. I think that's a latitude that is given to companies that can be defensible. Socially beneficial purposes are currently limited to public entities with the possibility of prescribing by regulations other entities, which I assume means potentially...
But that doesn't say that in 35. 35 is open to anybody.
Yes.
It's any organization. It doesn't restrict it to social good. It doesn't have any restrictions whatsoever. It just says that an organization, if they decide it, can breach your personal information and do it without consent and provide it to other people for statistical purposes or research purposes. To anybody. It doesn't say to business, doesn't say to universities, doesn't say to the government. It's available to anybody under this.
But this has been interpreted so far as essentially in the domain of public interest statistical purposes as opposed to purely commercial.
But businesses do research.
I understand.
Biotech firms
I understand.
do research.
I understand.
So...
Thank you very much. Ça conclut tout le temps qu'on avait pour cette rencontre. Merci.
That was all the time we had for this meeting. Thank you very much, dear colleagues. We had very interesting discussions. Thank you, witnesses, for taking time to come to see us. Thanks to the technicians, interpreters, and analysts. Meeting adjourned.